Hello again. Welcome to another edition of MasterMind Minutes. My name is Gary Occhiogrosso. I am the managing partner for Franchise Growth Solutions. That's this big poster in back of us. You can learn more about Franchise Growth Solutions by going to our website, clicking the link above or below, as we always say. And MasterMind Minutes is a little bit different today. It's actually MasterMind Minutes Plus, because normally we have one guest. Today we have two. Normally we have one question. Today we have a few, but I guarantee that we will still keep it within minutes, not hours. So I'm very excited today about our guests. Let me start by introducing Joel Greenwald. Joel is the founder and managing partner of Greenwald Doherty, LLP, a national management side employment law firm focusing on labor relations and employment law. Joel advises and represents management on a myriad of longstanding and current employment legal issues. And Joel, thank you very much for being here. I appreciate you taking the time. Our second guest is actually the first returning guest we've ever had here on MasterMind Minutes, Michael Einbinder. And Michael is the founding partner of Einbinder Dunn. He's a participating member of the American Bar Association Forum on Franchising, as well as a member of the International Franchise Association. Michael represents startups, emerging and established franchisors, and single and multi-unit franchisees, as well as private equity investors in franchise transactions. Michael, thank you very much for taking the time to be back with us today.
Thank you, Gary.
We've got a very important topic that I'm hearing from my clients regarding labor, kind of the reopening now of the economy. I don't want to say after COVID. I think, there's got a little bit to go, but clearly the world is reopening. Employees are coming back to work. I'm getting questions from franchisors as well as franchisees. Hey, what should we know? What should we look out for? So Joel, I want to start with you. Given your area of expertise in employment law, what should employers be thinking about with respect to liability concerning employees getting coronavirus at the workplace once there's a return to work?
Yeah, thanks so much, Gary. I think, and thank you for having me on your program. Look, negligence lawsuits from getting coronavirus at work is a chaotic situation right now. We don't know where it's going to go. Right now, there's a lot of uncertainty. There's some political discussions, I would say maybe heated discussions about whether or not there should be a liability shield. Okay, and certainly some people believe that there should be a liability shield for businesses because it's already difficult enough for companies to think about reopening. And if there isn't a liability shield, people are going to be afraid to reopen, get back to work. And it is a real concern. It is a real concern. And I think there's some validity. On the other hand, there's some concern that if there's a liability shield and companies are not liable for people getting coronavirus, employees getting coronavirus at work, then they will potentially have a situation where workplace safety will be disregarded. Lawsuits have a way of keeping that in check. Coupled with that, there's the question of whether or not workers' compensation insurance picks up for these kinds of lawsuits. Typically, negligence lawsuits are preempted for workplace injury. Somebody loses an arm in a factory, something like that, then ultimately, you're an employee, you're not an independent contractor. You can't sue the company for a personal injury action. You simply have to get your workers' comp. But workers' comp isn't something that would normally pick up for a virus. Also, with a virus, it's hard to prove that you get the virus at work. Okay, so that's a difficult situation. Also, workers' comp laws are state by state, so it's not clear right now if workers' comp is going to be picked up for these kinds of actions. California has indicated that there will be coverage. Most states haven't indicated anything as of yet, but just like the liability shield is leaving things in flux, this is leaving things in flux in terms of workers' comp. So the idea that workplaces could be facing down coronavirus lawsuits, negligence lawsuits based on coronavirus, is going to be a potential big issue as we move forward. Also, just as an aside, if workers complain about safety and the employer takes some sort of an adverse employment action, like they fire them, okay, and then the employee can potentially sue for retaliation under the OSHA rules. Now, I will say this, that all the employer can do right now is be cognizant of their safety planning. And I don't think that that's a little thing. I think that's a big deal. So they've got to set up proper safety protocols and policies. Employers need to be doing that now. Some of them have reopened already and haven't done that. They need to do it immediately. Employers should be looking for guidance from the CDC, from OSHA, from the EEOC, from state and local authorities, maybe even their industry associations or colleagues, good safety ideas, because everybody knows their business best. Lawyers can only be so helpful here. You know your own business. And I think once you do set up a safety plan, maybe a safety planning committee helps, maybe there's a chief safety officer that you name, but you've got to start budgeting and planning for safety. And then you need to implement a strong and clear safety plan, maybe a policy as well. And I want to have some proof that employees have been trained on it, understand it, and it's been communicated adequately to them. So that's something that's important. Also, just some examples of some things that I think employers are doing. They're obviously creating a environment that's safer. They're making sure that the PPE, like the masks and face coverings, are available. They potentially are doing testing, whether it's temperature taking, which the EEOC has permitted, or COVID testing. Physical distancing, making sure that people stay 6 feet apart, staggering shifts, common area restrictions. So, you know, the lunchroom and the water cooler, people can't be around them. Maybe the bathrooms have limited people in them at once. Cleaning and disinfecting rules, workplace modifications, airflow modifications, barrier modifications. Those are the kinds of things we're seeing and talking about. Also, companies will be making changes in terms of visitors coming to the office, vendors coming to the office, clients coming to the office. These are the kinds of things, amongst many others, and the sand is shifting as to what companies need to do. Because with this liability uncertainty, and it is right now a little chaotic and uncertain, and it may change in the next day, month, week, we're forecasting. I find that we're weather forecasting more than anything else right now. You know, it's hard to know where some of this lands, but with the potential availability of legal action through negligence lawsuits for employees catching COVID-19, the one thing that you can control is making sure that your safety protocols are really set up correctly.
Mm-hmm. Mm-hmm. Well, you know, it sounds oh so complicated, I have to tell you, just in terms of so many details and different things that employers have to now be careful for. You know, let me just take a minute, and Joel touched on it. I just want to maybe exemplify or amplify rather the idea that, you know, every state has different rules, every state has different laws. So, you know, I guess I would want to make sure that everyone listening certainly, you know, seek your own counsel with your attorney in your state, really to understand how it's going to work. But, you know, I understand it and I get it. It just sounds like there's so many tripwires, so to speak. And I don't use the term negatively. It just seems that if the employer does one small thing wrong, that they can get in trouble. Now let's add another layer on top of this, okay? Kind of the arena that Michael and I play in this franchise world, where you've got now not only the relationship of the employer to the employee, we have this other relationship with the franchisor to the franchisee. So, Michael, and you know, this has been a hot issue the last few years. What I'm about to bring up is, you know, what advice should franchisors give to their franchisees to address the issues Joel just talked about, but while being sure that, you know, they need to consider the joint employer concerns where they're not considered a joint employer?
Right. Yeah, and I think, thank you for having me again, Gary, by the way. And Joel, Joel succinctly told us as best we can at this point in time what needs to be done as much as you can to protect yourself. Well, franchisors and franchisees should look to one another. Franchisees should be expecting, and I know that my franchisee clients are expecting guidance from their franchisors about what to do and how to do it and how to address the issues that Joel's talking about. And what franchisors should be doing, in my opinion, and what I tell my franchisor clients is they should develop comprehensive plans along the lines of what Joel is talking about to address the concerns, workplace concerns, for both customers and for employees as well as customers who come into an establishment, because we do want these people to be safe in that environment, both to protect them from ailments as well as to obviously protect them from liability. So the first thing I'm recommending that people do is actually create policies and procedures that they can share with their franchisees. I'll get to the joint employer issue in a couple of minutes, but it's critical because franchisees are typically looking to franchisors for all sorts of policies and all sorts of procedures and expect to get them on a regular basis. And we're no longer in the days where you have to print something up and then send it out. Most franchisors, Gary, as you well know, have their operations manuals online on our website, and they send out updates all the time. And now should be the time that we're sending out updates. And as an aside here, we represent a number of franchisors that have company-owned units as well as franchise units. And so they're implementing these policies across the board, or they're trying to. So what can you do to approve or make sure that franchisees follow these rules? Every FDD that I've ever read or written has a provision, generally at the end of section 1, of item 1, that tells franchisees that they have to comply with local laws and government regulations. Start there. Tell your franchisees that they should look, as you said, and as we have talked about, for guidance from the federal government, from the CDC, from infectious disease specialists, and so on in the government about what to do and how to do it and what the safest way to do it is. Look to local government regulations about what they're expecting in those local, what those local jurisdictions are telling people to do. Follow those rules. Franchisees who do not comply with local laws are going to be in violation of their franchise agreements. And you may want to remind your franchisee that we take this very seriously, and we want franchisees to comply with all local regulations and government regulations, and that they're on top of that kind of information and detail, because it does change from day to day and time to time. And it will change through the various phases that locations are going through. So for example, New York is just in phase 1. Upstate New York City, that is. Upstate New York is in phase 2. So there are different rules and they change all the time. So the first thing you tell your franchisees is follow the law. Second thing is, we think we're going to do the following. We're doing the following in our company-owned stores. We want you to do the following in your stores for the safety of the people who work there and for your customers, because you don't want anyone to get sick and you want to protect yourself. So what can you do about that to mandate that without the concern for joint employer? Talk about shifting sands, Joel. The landscape of joint employer liability has changed so much since the first time we started hearing that term 3 or so years ago. Right now, the pendulum is swinging to the side of not holding franchisors responsible for what their franchisees do and how they treat their employees. But my best advice is don't count on anything and be careful. So rather than mandating something other than compliance with local law, what you should be telling people is these are our recommendations and it's our advice. Get your own advice, follow your own regulations, make sure that you're compliant, as I said before, and these are the protocols that we're instituting and we believe you should, but you're responsible for these. You're responsible both for following these rules and implementing them and compliance with them going forward, so that every franchisee is sort of on their own, but with advice and counsel from their franchisee. And then one point I want to raise was Joe mentioned this about employees being covered by workers' comp. Independent contractors are not, correct, Joe?
That's correct.
So you really do need to be careful about the way, I'll use the word loosely, the way you employ people, because there is potential liability if you're treating people, putting aside a whole load of issues about independent contractors and whether or not you can actually have independent contractors in your business. If you have independent contractors or calling them, you're opening yourself up to some risk for liability that you wouldn't have if workers' comp was protecting people.
Well, and I'm going to add to that if I could, though. Prior to this pandemic, companies would always, there was a trend for companies to move towards trying to categorize people as independent contractors and hire independent contractors and say they're independent contractors. And the one big warning flag on that always was, besides the fact that the government doesn't necessarily like it, the idea is that, if somebody gets injured on the job, okay, an independent contractor can personally sue you. If they're an employee, there's problems with that.
Mm.
Right.
Yeah.
Right, and the law is changing in that respect too. Government regs are changing. California is leading the way, and before COVID hit, I think New York legislation and New Jersey and other bluer states, let's say, were implementing policies or starting to implement policies that would prohibit businesses from using independent contractors or categorizing people as independent contractors. But in terms of this concept, watch out for liability to independent contractors that's not covered by workers' comp.
And that's a great point. Michael, I just want to stick with you here for a minute, just for a kind of a follow-up question, because as a franchisor in the past myself and a franchisee and consulting with franchisors, as a franchisor, we are very focused on the procedures that our franchisees use, kind of the layout, how their facilities look, how they're set up. So with a lot of this going on now, and it being different in different places, different states, do you feel that franchisors have to approve the modifications that franchisees would make to their locations to protect their employees and their customers? What's the franchisor have to say about all of this?
Yeah. We all know that in the franchising world know that franchisors set up design packages for their franchisees and periodically modify those design packages in ways that are intended to improve the brand recognition and performance of the brand. To me, any change in the physical plant, in what the store looks like or what the other customer-facing parts of your business look like, is something that has to be approved by a franchisor, and that should be dictated and that can be dictated to a franchisee. This is what the new, Michael's Hamburgers is going to look like. It has to have plexiglass, and it has to have little places where people can pay without breathing on you, and it has to be set up in a way that protects staff and patrons. And I think you can dictate that, and I think you do that through an operations manual and a new design package. And if you're letting your franchisees, whether you're a new franchisor with 3, 4, 5, 10 franchisees, or a mature brand with many, many, many more, you really should be setting a program for what this is going to look like and help source and supply some of the materials that people are going to need. One client of mine talked to me a couple of weeks ago about mandating a specific PPE provider and making sure that all of its franchisees had the same masks, some not surprisingly branded, and that franchisees were told to use these kind of masks in this kind of environment, and this is what you should do, and doubling up on food requirements in terms of gloves and that kind of thing. And people these franchisors were giving advice to their franchisees to make sure, advice and mandating compliance with that. And I think it's a really good idea for franchisors to do that. Again, whether it's a small ZOR or a very large franchisor with a lot of franchisees, it's important to lead the way and make sure there's a consistency in the look and feel of the operations of your franchisees' businesses, for this world that we're going to inhabit for some time to come.
I got to tell you, as a franchisor, and I'm listening to you guys, I see a lot of just kind of spaghetti entanglement of the employer, the employee, the franchisor, because, the franchisor may, dictate to the franchisee, hey, we want you to do this way, or the employer, let's say it's not a franchise, says, hey, given COVID, this is what we need to do. My question, Joel, this really would be for you, is, what discrimination issues present themselves to employers as a result of the current pandemic, and how they have to deal with it.
Oh yeah, great question, Gary. And I think it's multifaceted. That's a rich question, because I think that there's really two separate things I see in terms of discrimination, two separate categories, if you will. One is the discrimination category in terms of decision-making concerning who you reemploy, who you bring back from layoffs and furloughs. That's one thing. And then there are discrimination issues concerned with who you bring back to the physical location who may have been telecommuting. And I'd like to address them one by one if I can. I'll take a few moments. But if we're bringing people back off of layoffs and furloughs, we may be bringing them back in phases, maybe not all at once. We may be bringing back the people that we deem to be the most essential people first. Now, there, we always have to be cognizant, just like when we're firing people or laying them off or reducing their hours or whatever it may be, that we're cognizant of race, gender, religion, age, all the protected classes, pregnancy, there's many more, okay, of discrimination, so that we're not discriminating against people in terms of how we're reemploying them, when they're reemploying, because people will say, hey, you reemployed this category, but you didn't bring any of us back, and there's that risk. So it's always best if those decisions are made based on objective factors, not subjective factors, if possible. Meaning seniority. I'm bringing back my most senior workers, the people that have been with me the longest, not necessarily the oldest, but people that, I have the most operational needs for these people. These are the skill sets I want. These are the people that have the highest sales numbers or hours work or whatever it may be. I'm bringing them back under some specific objective criterion that's always going to be safer. The more objective you can be based on documented history or so forth, you're going to have a level more of safety in terms of your defense for being discriminatory. That being said,
can I break in for a second, Joe?
Sure.
Is that something you should document? I mean, in terms of communicating with franchisees or with employees or franchisees for that matter? Is it something that you want to document? This is the criteria in which I brought these people back, or is it an internal thing that you should document? What's your safest course?
It's a good question, and I think you asked a few questions in there. I think just based on what you were saying from a joint employer liability perspective, I'd be hesitant for the franchisor to tell that kind of thing to the franchisee. However, I think, the individual business itself, let's say the franchisee, hypothetically, I think you're probably best documenting that internally. I think that would be the safest thing to do.
And I want to just ask you a question, Joel. Again, I know you have another point to make on this topic, but let me just ask you, because I'm hearing this from a lot from my restaurant clients, my retail clients, that the employees don't want to come back. Now, some people are saying, well, I'm making more money on unemployment, but legitimately, they may have fears. Legitimately, they may have depressed immune systems. Maybe they have, post-cancer patients. Maybe they don't feel that the facility is safe enough. Could those folks say, hey, my boss is forcing me to come back to work. I'm being discriminated against because I'm either afraid to do it or I have some other condition that makes me more vulnerable. I mean, where does that discrimination line? It just seems like it gets all blurred.
I think, Gary, that really ties into my second point, which is
okay.
So I think it's a good question, which is the other thing is that when you're bringing employees back to work, and I'm talking about back to the physical location, because some workers have been able to telecommute. Okay, so we're not necessarily talking about reemploying them, period. People, managers of places and so forth, they may have been able to work remotely for a time being, whatever it is. You may have brought them back a little earlier because of your PPP loans, whatever it may be. But I'm actually talking about bringing them back to the physical location. If you're bringing them back to the physical location, one of the things that you actually can't do or should not do in most instances is make a decision based on their perceived higher risk. So that, oh, you're over 65, you've got a chronic health condition, you're pregnant, you've got diabetes, heart disease, moderate to severe asthma, and I'm making a determination it's safer for you not to come. That's a decision a lot of employers are making, and I think it's the converse of what you said, which is making a decision, I don't want you to come because of that. And frankly, that is something that I think that you really have to be careful to do. There's rare exceptions. The EEOC has come out with guidance recently and has said you can't do that. You can't discriminate against people based on a perceived risk. That being said, there's a rare exception. If the disability poses a major threat to the employee and it can't be eliminated or reduced by a reasonable accommodation, and there's many, many factors that go into that decision. And I think that brings me to the next point. If, let's say, and this is, I think, getting closer to where you are, is if somebody says, I want a reasonable accommodation. I want an accommodation because I don't feel safe, okay? And I want an accommodation, and I don't feel safe because I am over 65. I am somebody suffering from one of those underlying conditions. I've got the heart disease, the diabetes, the asthma, whatever it may be, or potentially a mental disability, like an anxiety disorder that's being recognized, some of those things. Then I think that you have to do everything you can to open up the dialogue with them, listen to them, and potentially provide some reasonable accommodation for them if it's possible. Now, the law of reasonable accommodation is the reasonable accommodation cannot pose an undue hardship, but it may pose an undue hardship. Maybe there's no accommodation for them that won't pose an undue hardship, but that's an analysis that has to be taken. And frankly, I think you have to run those by counsel. If somebody is just scared and they haven't stated a reason, then I think that it doesn't fall within the same protections of the law. That being said, if somebody comes back to work and sees that and this is a tight issue, if somebody sees that there are some safety concerns once they come back to work, and then you take an adverse employment action, as I mentioned before, you maybe suspend them, put them on unpaid leave, do certain things like that because they're making a complaint about the safety, I think you run the risk of a retaliation lawsuit and exposure for that too. One of the big problems though is that people, they are looking to stay home. They're collecting more in some instances, staying home. That won't last indefinitely. But there's another consideration to that, which is some folks have received PPP loans, okay? And part of the problem is they're having trouble meeting their full-time equivalency numbers, okay, because people are not coming back to work. The best advice based on the Treasury Department is to send them correspondence demonstrating that they have not come back, that they have been offered a job and that they are not accepting the job and refusing to come back to work. And then there's other steps you can follow along those same lines. But once again, that's something you may want to consult with counsel about too.
Well, let me, and I have one last question that I'm going to toss over to Michael, but before I do that, I just want to emphasize to everyone watching and listening, and, you know, as a non-attorney here, you know, sometimes attorneys bear the brunt of, oh, we got to get the lawyers involved. But I just want to underscore here the complexity, and again, I'm going to use that term tripwire, but the complexity of this issue of employees, employers, franchisees, franchisors, bringing people back to work. What is discrimination? What's safe? There are a lot of icebergs to navigate. So folks, I cannot emphasize enough, if you're running a business, you need to have not only great counselors like our two guests today, but you need to plug in. You need to pick up the phone, send them an email, plug in, get that advice, because as you can see, this is not something that's going to be answered in our 20-minute conversation. There's a lot more to it. So that, I mean, I just want to emphasize that. Yeah, Joe.
Can I just add one more thing? And thank you for mentioning that,
Yeah.
Gary. I'll tell you, the landscape's interesting right now. Our firm does nothing but HR law for companies, human resources law for companies. That's what we do, call employment and labor. And we've had a firm for 22 and a half years, and we represent nothing but employers. It's so interesting, though. The phone has been ringing off the hook. The employers are calling us, even for a 15-minute call, because they're scared of being sued. And they're right to be scared of being sued, because there's a lot out there. And we would prefer somebody call us in advance than wait for litigation down the line. And we're urging companies to do. We're putting out more content than ever. We want to inform companies that they have to take deliberate actions here, and they have to know what they're doing, because if you do this willy-nilly, I think you're going to get in trouble.
Yeah, I agree. I mean, we've got to be very careful of the stepping stones that we're crossing, you know, through the raging river. So my recommendation, again, as always, on a lot of issues, but this just, and I think it's compounded because things are changing constantly and very quickly, that, you know, the advice that you may get from your attorney on a Monday, well, maybe the following week there's been some changes, and, you know, things are different. So I don't think it's a one and done scenario. I think employers, business people need to stay very close to their legal counsel during this reopening phase and during this time, maybe more so than ever. Michael, okay, so just to kind of wrap it up, because getting, you know, kind of connecting now back to the arena that we play in, this franchising arena, I guess generally, you know, what would you say franchisors, what should they do to deal with, you know, I've heard the term the new norm, which I'm not crazy about. I prefer to think of it as a temporary norm. But, you know, in the world of franchising, you know, we've got documents, FDDs, there's FPRs, we're dealing with closures, supply chains, approved suppliers. What are the things that franchisors should be focusing on now to deal with all of this?
Well, specifically, you know, dealing with the stuff we're talking about, I'll get to the more general in a minute. What franchisors should be doing is taking counsel from someone who does what Joel does and someone that does what I do, to give them advice on how to navigate the landscape for their franchisees. So I'm not suggesting that a franchisor communicate with the franchisee's employees about how the franchise employees can come back to work or not. I mean, I think the franchisor needs to tell its franchisees, document what you're going to do, what your plan is, make sure you have record keeping so that you can protect yourself in the event that someone raises a claim concerning the discrimination in how you rehired people, or whatever it is. I mean, I think documentation is especially critical at this point in time, and franchisors should advise their franchisees to make sure they keep track of this kind of thing as they do with all their records. In general, though, whether it's the new normal or the new temporary normal or whatever we want to call it, you know, the documents that we use to sell franchises are living documents, and they change with what happens. And you know what I'm starting to see and what we're starting to do, I was concerned about anybody selling franchises in March and April. I just thought, you know, especially given the timing in terms of when renewals were happening, maybe it was best to wait a little bit of time to see what it was all going to look like. But that the information then in FDDs is not accurate anymore, or is potentially not misleading, but simply not an accurate story of what's going on in your world. So you have 75 franchisees. Well, it's possible that 25 of those guys are going to be out of business next year.
Right, right.
And you have FBRs that are from the last 3 years when business was great, but it wasn't so great for the first 6 months. And obviously there's going to be a real downturn in revenues for most businesses during this period of time, unless you're selling PPE equipment and plexiglass. You know, everything else has gone down, other than Home Depot, I guess is the other thing. But I mean, there's a lot of businesses that are suffering, and I think you have to take that into account in your documentation. So we're telling our clients that, notwithstanding the fact that they may have registered their franchise, you know, by April 30th, so we've done an FDD, we should revisit that FDD and do an amendment to cover the fact in all red capital letters that the world has undergone a significant downturn in economic activity.
Yeah, Michael, we could do a whole program just on how the impact, and I don't want to get into it now, but how it impacts item 19 and what you're presenting to potential buyers and what their thoughts might be if they're looking at sales of 2019, thinking that might be the same in 2020. So clearly, like I said, that's a whole program in itself, but that would be an issue.
Certainly something you have to be very, very careful about. And then, of course, you're going to have a lot of franchisees, as I said, who have gone out of business or have had significant downturns, and maybe they've closed a unit or two. And you have to account for that. And if half your system is gone, let's just say, for the sake of argument, how can you have an FDD that says I have 25 franchisees and gives out telephone numbers that don't exist anymore, or where there's no operations anymore? So I think you have to supplement some of that activity, some of the documentation now, and consider doing it before you start selling franchises again, or do it on an ongoing basis, because things are going to change. There's also, you know, there are issues about closures. There are issues. What do you do with franchisees who have ceased operating? How much time do you want to give them? What kind of notice do you have to give them if you want to find out if they're getting back in business? And if they are, what does that mean? Is that a default? Are you going to default them? I don't think anyone really wants to default their
I
franchise.
would hope not.
Close during this period of time, but make sure you're documenting your franchisees, or you're documenting what's going on with your franchisees, and be careful about it. Obviously, there are issues about supply chain. I mean, obviously there are businesses that are approved suppliers that don't exist anymore, or that are unable to supply. So do you have to expand your approved supplier network? Are you going to approve new suppliers more quickly than you did in the past? What kind of accommodations are you going to make to do that? And then with respect to all this sort of operations manual advice or statements or rules and regulations, rules of the road, plexiglass and other things that you are going to make franchisees incorporate into the physical plant, make sure you're doing that and documenting on an ongoing basis. Make sure you're documenting as many of the things that Joel is talking about in terms of following these regulations. Maybe you put out a special operations manual relating to employment, or a special supplement relating to employment issues. You have a lot of information that you give to franchisees on an ongoing basis that really has to take this kind of information, this kind of stuff into account. And one of the things we're talking about with a lot of clients, especially in the restaurant business, and you must be doing this as well, the world is going to at least change for a period of time, right? And so there's going to be a lot more delivery, and there's going to be a lot more ghost kitchen kind of stuff, and there's going to be a lot more activities that is away from the physical restaurant. Maybe there's going to be more commissaries. Maybe there's some difference in the way franchisees will operate. Start thinking about, for franchisors, start thinking about what that's going to look like, and start modifying your agreements to allow for those kinds of changes. And let franchisees, with existing franchisees, do amendments with new franchisees, do documents that make sure that you allow them or require them to use ghost kitchens for delivery, if that's the best way to do it. There are a million things, and Gary, you're right. There's about an hour's worth conversation and just what the FTD, what every item in the FTD is.
Well, all right. So we'll save it for another program, because
this is really critical stuff, and this is an avoidance of liability and also operations of your franchise system in the most
and I can't emphasize enough, again, stay close to your attorney, and and again, Michael, we'll kind of revisit this in subsequent programs, but just to kind of round this out and kind of close it out, Joel, any last word you want to give, and how can folks contact you? And then Michael, I'll ask you the same thing, but let's start with Joel.
Well, thanks. I think I'm just going to reiterate that I think that you have to think about these things. I think you have to be deliberate. I think that, when we're talking about safety planning, maybe form a committee. Okay, maybe create a chief safety officer. Going back to some of the things Michael was saying, you may have to create a safety budget if you're a business. Okay, that's a line item budgetary thing that you haven't thought about before. You do want to document the decision making you're going through. You do not want to face down a discrimination lawsuit, because those may be systemics, though those may be class actions. You don't want a situation where employees have they have a viable lawsuit and they are able to come after you, because it's going to be hard enough to keep operating when everything gets back to normal. The last thing you need is an employee lawsuit. So for us, we're easy to reach. We've got offices in 6 states, but we counsel companies in plenty of places. The best way to reach me is at my email at jg@greenwaldllp.com. And my phone number is 212-644-1310. And feel free to reach out. If it's a few minutes, you just want to run something by me, please let me know.
Great. Michael, any last word and your contact info? And again, remember, it'll all be posted, but go ahead, Michael.
I think Joel's advice to be deliberate about what you're going to do is
keyword deliberate.
Absolutely. You really have to figure it out, and you really have to have a plan. And doing this haphazardly is absolutely unequivocally the worst thing that you can do. Put as much as you can in writing and make sure it's covered. And start thinking about it, not from just the franchisee's perspective vis-a-vis employees, but also for the patrons of the operations of those franchisees. You don't want someone to accuse your franchisee of operating a location that wasn't safe and claiming that they got COVID-19 from eating a hamburger someplace.
Right.
So let's be as careful as we can in terms of how we operate. And to Joel's point a moment ago, I think you raised it, but we might want to start thinking about modifying your insurance requirements also. A few years ago, we started adding employment claims kind of insurance to the list of insurances that we required franchisees to get. I think we really have to get this kind of insurance to the extent it's possible to get it. Maybe even recommend to franchisees that they get business interruption insurance if they don't have it.
Premises liability too.
What's that?
Maybe premises liability insurance.
Well, they usually are required to get that under their FTD, under the franchise agreement. But we may be able to modify that in operations manual, depending on how you wrote the operations manual provisions in the franchise agreement. But insurance requirements can be added. Generally, that's my kind of takeaway from all of what we're talking about. For me, I'm happy to have a conversation with anybody about any of this at any time. I am reachable through my email at me, which are my initials, me@ed-lawfirm.com. You can reach me at my office. I'll leave a message because no one's there right now because we're not back yet, but it's 212-391-9500. I'm happy to have a conversation that can sort of help you lead the way towards doing what we're talking about and to incorporate Joel into those conversations if it's a combination of the work that he does in the combination of the work with the combination of what we do.
Wow.
Just be as careful as you can and make sure that you're working on keeping your employees and patrons safe.
Well, it's great information, gentlemen, and I can't thank you enough for actually participating in this extended version of MasterMind Minutes. I don't think this is a topic you can cover in 10 minutes. And certainly, again, just to kind of reinforce what I said earlier, the laws are different everywhere. So, get good, strong legal advice from your attorney. But I think the key word that Joel mentioned before, deliberate, I think that's a key word here. And again, I want to thank you for being with us, and hopefully, we'll get together again, perhaps on a different topic. But folks who are listening, remember you can get their contact information right on the text that'll accompany the program format. And please feel free to reach out to Joel and Michael. And guys, just thank you so much. I appreciate you being here today.
Thank you.
Thanks.